There are a couple of bills that caught my eye in looking at the 2024 bill introductions in the California legislature, being the legislative geek that I am. One bill had 200 or has 227 individual sections, which is by far the most I've seen. They include changing sections in the Business and Professions Code, Civil Code, Code of Civil Procedure, Education Code, Evidence Code, Financial Code, Fish and Game Code, Government Code, Harbors and Navigation Code, Labor Code, Health and Safety Code, Public Contract Code, Public Resources Code, Public Utilities Code, Revenue and Taxation Code, Streets and Highways Code, Vehicle Code, and the Water Code. So other than the budget bill, that's a lot of code sections. Why is this provision necessary? Nothing in this section restricts the right of the public to use navigable waters for hunting, fishing, or other public purpose as guaranteed under Section 4 of Article 10 of the California Constitution. I mean, isn't that kind of obvious? A state statute can't contradict the Constitution. I found this to be an interesting provision. This act does not affect and shall not be construed to affect the validity of City of Woodland Measure S in 2004. Its applicability to any flood control project, including the subject of this act, or the outcome of the litigation in Yolo County Farm Bureau versus City of Woodland from the 3rd District Court of Appeal. Now, on occasion, the legislature addresses an appellate court decision, usually to abrogate it or get rid of it, but in this case, the intent is to not disrupt the appeals court decision. SB 1076 is doing things the right way, in my opinion. Here's the plus section at the end of the bill. The legislature finds and declares that this act furthers the purposes and intent of the California Privacy Rights Act of 2020 by ensuring consumers' rights, including the constitutional right to privacy, are protected by enacting additional consumer protection provisions regarding consumers' requests that data brokers delete their personal information, including additional safeguards related to consumers' use of authorized agents to make those requests. Now, I really appreciate when bills that amend a statutory initiative actually explain why the bill furthers the purposes of that ballot measure. In most bills, we find just standard language that doesn't do it for me. The standard language is the legislature finds and declares that this act furthers the purposes and intent of the California Privacy Rights Act of 2020. So you can see in the earlier version in SB 1076, a paragraph explanation as to why it does further the purposes and intent. I always chuckle when reading the maxims of jurisprudence, which were enacted in 1872 in the California Civil Code. This is from a bill. Existing law provides certain maxims of jurisprudence, including acquiescence in error takes away the right of objecting to it. So this bill would add to the maxims of jurisprudence described that the exceptions and qualifications to maxims are more important than the so-called maxims. So this would actually add to Section 3549 of the Civil Code the following. The exceptions and qualifications to maxims are more important than the so-called maxims. Now, this is what we might call a substantive spot bill, clearly a placeholder for other substantive language to come forth soon.